back to winning isn't easy. Can an ERISA claim administrator like Sedgwick get away with a denial based on a non-specialty IME in an RSD claim? Well, I will tell you, in my opinion, the Sixth Circuit got it wrong in the case of Avery versus Sedgwick claims. And I think this is a lesson to be learned for all, because you can't depend ultimately on courts to save you from bad acts of people like Sedgwick. Avery developed advanced peripheral demyelinization and polyneuropathy of the lower legs as a result of an ankle fracture. Her disability policy was administered by Sedgwick, who, as we know, administers claims in a biased fashion. After she was paid benefits for 2 years, the standard of disability changed from an inability to do her own occupation to an inability to do any occupation. Now, the game that's played by carriers and claims administrators at this stage is to create medical evidence that a policyholder or plan beneficiary can do sedentary work. So how do they do that? Well, they use liar-for-hire medical reviewers and not so independent medical evaluators to give them an opinion that the policyholder or plan beneficiary can do sedentary work. That basically means sitting 6 out of 8 hours, lifting no more than 10 pounds with minimal walking. Now, what happens is, if in that case, the policyholder or plan beneficiary has to appeal a wrongful denial. And if they're not successful on appeal, they have to file a lawsuit in federal court. What happens in federal court depends on what the standard of review is. And the worst standard of review is arbitrary and capricious. Now, that sounds easy, but basically it is a golden handcuff on judges who are really limited as to what they can do in overturning a wrong denial or termination. Now, the preferable standard of review is de novo. And that's where the judge can look at the evidence and reach their own independent conclusion as to whether the denial or termination is legally correct. ERISA regulations regarding claims handling were designed to give policyholders and plan beneficiaries protections. But many times courts will use what's called a substantial compliance test. This is a court-created test. It's not in the statute. It's not in the ERISA regulations. And they'll use this substantial compliance to say, well, they sort of substantially complied, so my hands are tied. I'm going to uphold this denial or termination. In my opinion, substantial compliance, and I'm going to use a legal term, is bullshit. In Avery's case, Sedgwick had her undergo a liar-for-hire IME doctor. Not uncommon. The physician was not a neurologist or specialized in RSD, reflex sympathetic dystrophy. Should be a problem. They had the IME report and her medical records reviewed by a neurologist who opined, she could do sedentary work. The Sixth Circuit ruled that since Sedgwick had a paper review by a neurologist and didn't really review on the non-specialist IME doctor, it had substantially complied with the ERISA regulations. Really? ERISA regulations require that a plan consult with a healthcare professional who has appropriate training and experience in the field of medicine involved in medical judgment. It is not just when you deny the claim, it's during the appeal process. And even if you try to make up reasons, you should be having at least an expert in the field of medicine involved rendering it an opinion. So in my view, the non-expert's opinion that was used in the denial was inappropriate. And the court said, well, he wasn't consulted during this appeal. His training and experience was procedurally irrelevant. But the problem is that the whole foundation of this denial was based on the non-expert. That's where it started. Yeah, they got an IME. They got an IME from somebody who, again, was not necessarily competent or qualified. And so what we really have, in my view, was a whole denial predicated on non-expert opinions. Yeah, you might be a neurologist, but what experience did this neurologist have with reflex sympathetic dystrophy? I tell you, it's a highly specialized diagnosis, which is not treated by every physician, much less a neurologist. The court's unwillingness to acknowledge this and to frame their decision as procedurally irrelevant, I think, ignores the reality of ERISA claims, where the games are played with the purpose and intention of creating a denial. Remember, Sedgwick said, They can count on us to listen, to respond, to protect, and help make things right. Bullshit. Not in this case. The court let Sedgwick get away with robbery. Let's take a break.